Thank you. Neat. Thank you both. Just a few preliminaries before we get started. I've got appearance sheets. We'll do one appearance sheet. And this is a disciplinary matter, is that correct? And as you may know, I know very little about the case, but I'll ask you to just put your names. If you had party representatives with you, I'd have you list them too, but since it's just the two of you, we'll just have your names so I have a record of the participants here today. Thanks. Right. And it's Mr. Lippert? Sure. Okay, thank you. Right, thank you. And you're representing the union?
Yes.
Yeah. And it's Wadsworth?
Yes.
That's an A, is that right?
Yep.
Okay, Mr. Wadsworth, thank you. Just before we go any further, I note that I don't see a court reporter present, so that means that you don't plan to have a transcript of today's hearing prepared. And along those lines, I also just want to establish that no one is making a recording of today's proceeding. If we had a court reporter, I'd say that the court reporter can use any device they deem appropriate. But there'll be no recording, no broadcasting, no live streaming or tweeting of any portion of today's proceeding, which is a private proceeding. That's one of the characteristics of arbitration. I'll be taking notes, some by hand, some in my laptop, and but that is not set to a record function, just so everyone understands that. Now, if we can take a moment and talk about exhibits, I think you probably have a collective bargaining agreement under which this grievance was filed. Is that correct? Okay, and this matches what you consider to be. Okay. One of the first things I always do, since I've not worked with you as counsel or with the parties or under this collective bargaining agreement, I do like to check the arbitration clause just to make sure that there's nothing particular about the way in which I need to conduct this proceeding. And I see that it's a routine arbitration clause. All right, which is good to know. All right, with that, then let me ask, do you have any other documents that could be joint exhibits that would be just admitted by agreement?
We have the termination notice for the grievance and the grievance document themselves.
Okay. Wonderful. And these are joint?
They are joint, yes.
So let's consider the collective bargaining agreement joint 1. And the termination notice, we'll consider that joint 2. And then the grievance document, which I see has also the responses from the levels within the school system. So that will be joint 3. Right. Now, you may have party exhibits that you'll want to present as you call your witnesses. And you may identify those through the customary process. Just before you show it to the witness, you'll give it an identification. Union Exhibit 1, management or employer Exhibit 1. The only thing that I do want to make sure of is that you show opposing counsel any exhibit you're going to show to a witness, you show it to opposing counsel before you show it to the witness. So counsel will have the opportunity to take a look at it. And if you haven't seen it and need time to review it, you'll let me know. And that takes us through the exhibits. Anything else that we should talk about before we move into a discussion of the issue to be resolved? Anything relating to, okay. Have you talked about what the issue is under the collective bargaining agreement, which is the question I need to answer in my decision?
Yes, the union believes that we haven't discussed it yet, but we think it's straightforward. We see the issue as follows. If the employer has just cause to terminate the employment of the grievant, and if not, what shall be the remedy for that?
Okay. And what does the employer think of that?
I agree, but I would like to add reference to Article 10, which is the disciplinary provision of the CBA.
Right? Does the union agree?
Yes.
Excellent. So that's your just cause provision, will be just cause, just cause clause, will be found in Article 10. Excellent. All right. So with the agreed statement of the issue, we can move ahead to opening statements. Let me just ask, however, in terms of planning for the day, we'll talk a little bit more after you make your opening statements. Do either of you or do your party representatives have any time constraints that might affect our proceeding today?
Yeah, my client needs to conclude no later than 5 p.m. because of childcare responsibilities.
Right. I think that that should not be a problem, but we'll note that. We'll strive for a 5 end time, and we'll monitor our progress as we go along. And after we do opening statements, I'll talk with you about the agenda for the day, what witnesses you'll be calling, and just a rough estimate of the duration of direct examination of each. So we can have a little bit of a timed agenda to make sure that we stay on track to complete the hearing in one day, and also to ensure that we conclude by 5 which is, I think, a reasonable target time in any event. We are ready to proceed then with opening statements. Because it's a discipline case, the employer will have the burden of proof, and therefore we'll start with the employer. Let me ask if the union plans to make an opening statement immediately after the employers. Okay, thank you. I appreciate that. Sometimes the party without the burden chooses to reserve and to wait until they've heard the evidence. And that's a strategic choice that I leave to the party in that position. But it is tremendously helpful to have the opening from both parties at the outset, because it will shape my ability to make rulings as we move through the evidence. Right. If there's nothing else for us to discuss before we move into opening statements, then I'll just arrange here so I can take notes, and we will begin with the employer's opening, please.
Good morning, Madam Arbitrator, and thank you for being here. As you may know, ABC Education Systems is the largest private school system in the state, and its high school is widely respected for both its academic and its athletic programs. As indicated in our preliminary discussions, this case involves the termination of an employee, John Smith, who had worked as the head custodian at ABC High School. ABC Schools maintains an extremely strict zero tolerance policy that forbids any acts of violence or threats of violence in the school or in the course of school-related activities. That policy states specifically that a violation or it by an employee will result in serious discipline up to and including termination of employment. In this case, the grievant engaged in a serious breach of that policy while on premises and in the course of his duties and in the presence of students. Termination was the only option available in light of what was a wholly unacceptable threatening behavior against a member of our faculty. Specifically, we terminated the grievant because of an incident on the evening of October 9th following soccer practice. The soccer team had been preparing for an important tournament, practicing and holding strategy sessions every Monday, Wednesday, and Thursday night for weeks. On this evening, they had completed practice and then gathered in the gym for a usual pep talk. The upcoming tournament is important, and the team members were exuberant. Custodian Smith had been directed to stay late that evening on overtime, as had been the case with prior practices, to ensure that the gym, locker rooms, and other facilities were clean and ready to receive students the next morning. He had complained to the athletic director about the repeated evening overtime, and also that the soccer team often left a mess, but these were teenagers, and this is his job. When Custodian Smith arrived at the gym on the night of October 11th, the soccer coach was finishing a conversation with a few members of the team who then drifted away. The coach noted to the custodian that there was a Gatorade spill at the far end of the gym that needed to be cleaned up. The coach will testify that the custodian then approached him aggressively and stood very close, saying, "You and these spoiled brats are the reason I keep missing dinner with my family, and I'm tired of them behaving like hooligans, trashing the place every time they are here. You need to teach them better. If not, I don't know what will happen." The coach was alarmed and stepped away, saying, "Dude, just do your job." The coach returned to his office and will tell you in testimony that he felt shaken. The words, "if not, I don't know what will happen," echoed in his mind. Coach called the principal, who asked if she should come to the school. Coach said no, but that he was going to wait in his office until he was sure that the custodian had left the premises and then would go to his car and leave. The coach will testify that 30 minutes later, he heard the sounds of the lights shutting down and doors to the gym being secured. He walked to the front entrance and saw the custodian drive away. A few minutes later, however, he saw the custodian's truck return and circle the entrance. The coach felt, he will tell you, that he was being watched and stalked. The following day, the principal met with the coach, who provided a written summary of events, which we will offer into evidence. The principal then had the custodian and his union representative come in, and she asked the custodian to tell her about the prior evening. He acknowledged that he had been out of line and offered to apologize to the coach. He attributed his aggressiveness to frustration with the schedule, and he noted again that the soccer team, teenagers, I remind you, were messy. The custodian acknowledged that he was familiar with and had been trained on the zero tolerance policy. Principal reported this information to Superintendent West, who directed the principal to place the custodian on paid administrative leave until the matter could be fully investigated and a decision made. Dr. West also directed the principal to continue with the investigation, including inquiries to ascertain if any of the students present had heard or seen the interaction, or if any other faculty, staff, or parents were witnesses. Principal took those steps and learned that everyone had left the gym by the time the custodian began his tirade. Thus, there were no witnesses other than the coach. While the investigation was underway, however, the principal received several communications from parents who had heard about the situation and had become concerned about the safety of their children. Several expressed offense as they had learned that the custodian expressed the belief that it was the children who should be cleaning the gym and the restrooms. The principal explained to those parents that an investigation was being conducted and that the custodian was on leave while that was underway. The principal also attempted to address what we acknowledge was a misunderstanding by the parents regarding this custodian's complaint about the team members. We know that he was not proposing that the students do the actual cleaning, but the custodian's actions snowballed into a community reaction that reflects poorly on ABC schools. After full review of the facts, ABC schools decided that under their strict zero tolerance policy and in light of the need to ensure safety of the students, the staff, and the public, it had no choice but to terminate the custodian's employment for aggressive and threatening behavior. We are confident that after we have presented our evidence, Madam Arbitrator, you will agree and will find that the termination was for just cause and that the grievance is without merit. Thank you.
Thank you. And for the union, please.
Madam Arbitrator, thank you also for being here. We believe that there are a few points of fact on which there is no disagreement, but on central issues, the union profoundly disagrees that with the account presented and asserts that the employer will not be able to prove that Mr. Smith violated the zero tolerance policy or that he engaged in any form of inappropriate conduct. What we agree on is that Mr. Smith was being required to work a series of evening overtime assignments, often putting him in 12-hour days, that Mr. Smith and the coach spoke in the gym on the evening of October 9th, and that the soccer team consists of teenagers who routinely are very, very messy. Beyond that, we believe that the evidence will show a very different sequence of events and interaction. As an initial matter, the employer neglected to mention that Mr. Smith has been employed by the ABC education systems for 20 years, and in 2020 was promoted to head custodian of the high school. 2 decades of service, Mr. Smith has received not a single instance of discipline, that there has not been a single complaint about him or his work, and his employment reviews have been not just satisfactory, but glowing. We submit that the evidence will show that on the night of October 9th, Mr. Smith was simply doing his work with diligence and pride, as he has done for the last 20 years, and that he made a simple request to the coach. Mr. Smith will testify and will tell you that no form of threat or even what could be misconstrued as a threat was ever expressed. Mr. Smith acknowledges, as he told the principal, that he expressed frustration to the coach and he apologized for that. Frustration was expressing, however, took the form of a request that the coach instruct the team to maintain a basic level of personal responsibility for the school by disposing of their own trash and by maintaining just a modicum of hygiene in the restroom. Mr. Smith will also tell you that while he asked the athletic director to reduce his overtime assignments, Mr. Smith had no time vented to the coach about his work hours. Finally, as the topper to the account of the night, management asserts that Mr. Smith was stalking the coach by driving around the building. Mr. Smith will explain in testimony that he did drive back around past the front of the building, but his sole purpose, as his routine after closing the gym, was to move his vehicle to the side door to collect trash while he transports to the main administration collection facility. This is why he drove back past the front door. If the employer had bothered to conduct a proper investigation, they would have asked Mr. Smith about this and even could have verified Mr. Smith's practice by review of the parking lot videos. But they did not do that. They relied solely on the coach's account. It is well established in labor law that just cause requires, as fundamental element, proof of the alleged wrongdoing or policy breach. We assert that management will not be able to meet its burden to prove that the events occurred as alleged. Just cause also requires that a fair investigation is to be completed. As I just noted, this was not the case. Just cause also requires that discipline be commensurate with the offense and, in all but the most egregious instances, progressive and corrective in nature. The unit does not disagree that there are instances in which violation of no tolerance policy may appropriately lead to termination. Even if its proofs were to establish that the ABC schools described, which we assert they will not, the union argues that termination would not be remotely appropriate in light of the alleged action in Mr. Smith's long discipline-free service. But beyond that, just cause also requires that policies be enforced equitably, and the union will adduce ample proof that multiple other ABC employees, including the coach, have engaged in far more serious conduct than what was alleged here and has been issued simple warnings. In fact, our evidence will show that the coach, who is management's only witness to this interaction, has been the subject of multiple complaints, some with disciplinary action for inappropriate communication with other faculty, staff, students, and even parents. We assert that this not only affects the credibility of the coach's account, but also that is clear evidence of disparate treatment of Mr. Smith. We are confident that the record, when complete, will show that the grievant did not engage in any form of inappropriate conduct or commentary on the evening of October 9th, that the employer did not conduct a thorough investigation, and that even if the alleged misconduct were established by the employer, still lacks just cause for imposing a grossly disparate penalty of termination of this long-term employee's livelihood when other employees, including the coach, have been given nothing but more than a warning for far more serious conduct. For these reasons, after the taking of the evidence has concluded, we will be asking that the grievance will be sustained in full, that Mr. Smith be returned to his position as head custodian at the high school, and that he be awarded a full make-whole remedy, which would include full back pay, including the substantial overtime lost, as well as lost benefits and seniority.
Thank you. We would, at this point, discuss, as I mentioned earlier, our agenda for the day. We'd work through just a list of the witnesses that the employer intends to call, and we'd talk about the witnesses that the union intends to call, and we would work up that tentative agenda that I described to you. So at this point, though, I think we can move out of our formal presentation, and we can step out of character. I'll note that at this point, while everything has been cooperative, and for example, the parties agreed to joint exhibits, and those are in evidence, and there's no need to go through the process of identifying and moving them into evidence. And we've talked about the process that would be used for the party-based exhibits. The potential for things to go awry here starts to